My lord, I have a prayer in item number 7, my lord. My lord, my mother was not well, my lord. I pray for
Adjourn on the prayer of Mr. Chetama, then
Fine.
continue with each other on the personal inconvenience of the land council.
My lord, my lord.
Lordship, I'm mentioning for item number 8, Lordship. Lordship. Lordship, we are trying to find some
Let the item be called. No. Ahmad has a own personal reason. That's what we adjourned. 2016 matter, otherwise no adjournment.
we are
We
trying
may
to-
do it without that material. We may pass our order. This is only an opportunity given. Either you avail it or you don't avail it. That will not be a reason to further adjourn it. We'll call the matter. October. Listing. Listing all allowed.
Lordship, I'm
Yes.
bringing for an
Listing.
urgent listing.
All listing allowed. You
Listing.
don't have to make a mention. Please give it to the court master.
Lordship,
Yes, next item.
Lordship, I have an urgent listing, Lordship, for 2 more, Lordship. What happened, Lordship, in this case, Lordship? Lordship. Lordship.
Deputy, you have it? Please. So you are relying on page 17. For what purpose?
Petitioner grandfather name is appear Lordship.
Grandfather's name appears in.
Kadu Foki. It's serial number 2.
Who is the grandfather?
Kadu Foki Lordship. Page,
Ah.
17, page 17 Lordship.
Who is the grandfather?
Kadu Foki serial number 2 Lordship.
Kalu. Kalu Fakir is the grandfather. Son of Pobos.
Yes, Lordship.
Of which village?
Bogoriguri Pathar Lordship. Bogoriguri Pathar.
Where is the name of the village?
Top Lordship. Korija, Bijoni, Mojar, Bogoriguri Pathar.
So Bogoriguri Pathar, Kalu Fakir, yes, madam. Is the grandfather. Now, who is the father?
Page 26 Lordship. Page 26 serial number 3 Lordship. Abdul Fakir.
Page 23,
26 Lordship.
26. This is again another Chitra.
Yes, Lordship.
These people, they never voted or what? They are not in the voters list. Only
Registration
purchasing land.
1989 Lordship. Page 19. Father's name appeared.
Suppose one Kalu Fakir from Bangladesh, he came to India, purchased a plot of land, got his name entered, went back. Again, he came, his son comes in 1989, purchases another plot of land, goes back. Now in 2020, they say that, yes, we are there from before. Continuous voters list is an indication that the person all throughout existed. But if Kalu Fakir had purchased land in the year
58.
1958-59. Why his name never appeared in any voters list? Because these migrant people, first attempt is to enter your name in the voters list. That's the first thing you do after crossing over the border. Why this man, he's a family member, they never made application to have the name in the voters list?
Lordship, in 1989.
Hmm.
Before Lordship, I have knowledge, Lordship.
Yes, Mr. Sharma, what do you say? Because it is actually possible. Anybody can come in, purchase a plot of land, have his name entered in the Chita, go back. After 20 years, his son comes in, he also purchases another plot of land. Because when we purchase land here in Assam, there is no requirement to prove you're a citizen and all. Anybody who purchased, said it, he is the owner. So, even if the existence is proved, is the continuous existence proved? Suppose Kalu Fakir would have been there in 66 voters list of same village. We would have accepted this one. He must have purchased land in 50. Not a single voters list. Except for, I think, 1989.
Abul Fakir,
Abul Fakir, son of Kalu. Who is Abul Fakir?
Father, Lordship.
father of the
Father of the petitioner, Lordship.
petitioner. 89.
And second
1993 is good.
second Chita is Abul Fakir. Acha, Abul Fakir, Pita Kalu Fakir. Yes, what do you say?
Lordship.
This is motion, let us say.
I have no objections, but Lordship, link, how to establish our link, Lordship? Petitioner is,
No, but their case is Kalu Fakir purchased land in 1958-59.
yes,
Chita is there. Abdul Fakir, son of Kalu Fakir, purchased land in. This is of which year? Page 26.
Lordship.
1958, Lordship.
58,
No,
not 58. Kalu Fakir
60.
cannot purchase land in 58.
it is of 96, Lordship.
Hmm.
Second one is of 1996.
Where do you get that bit?
Page 26, 27, Lordship.
20. Acha.
26.
1996. And Kalu Fakir's, this Abdul Fakir name is there in 1989.
Yes, Lordship.
So if he is the son of the same Kalu Fakir,
Hmm.
who purchased land in 58,
But Lordship, Rabia Khatun.
who is Rabia Khatun?
Petitioner, Lordship.
Petitioner is again Rabia Khatun.
Rabia Khatun, Lordship. She has to establish her link with
Lordship, father adduced evidence, Lordship, in this.
Abdul Fakir adduced evidence. Which page?
Page 45, Lordship.
29,
45, Lordship.
45. Same village, na Bogori Guri Pata. Ethnic code 3D level, na ito. I mean. Oh, no, education means that. We should cross it. The lady never went to school. Did not go to school.
He may have Tamil Nama also. Tamil Nama.
That part.
Nothing is there. Then how do you know that this man who deposed before the tribunal, Abul Hussain claiming to be Kalu Fakir, is actually Abul Hussain, son of Kalu Fakir of that 89 voters list and so on? Was he cross-examined?
No, Lordship.
The Superintendent of Police Border, Borpeta, to cause an inquiry on the identity of GW2
Yes, Lordship.
of GW2 Abul Hussain, son of Kalu Fakir, village Bogoriguri, as to whether the person who had deposed before the tribunal is actually Abdul Hussain, son of Kalu Fakir of Bogori Pothar, whose name appears in the voters list of 1989, and the person who had also whose name also appears in the chita available at page 26 of the writ petition. Father has given it is okay. But I believe that another person has come. And any voters list of Abdul Hussain prior to 1989? No.
Not.
The lady never went to school, never got married. Family only believes in purchasing land from time to time. You verified that.
Also, Lordship, Kalu Fakir of page 17, as well as grandfather of the petitioner, Lordship.
And
Yes.
whether the person deposed is actually the grandson of Kalu Fakir of the
Son of Kalu Fakir.
no, is the son of Kalu Fakir, who had purchased land in 1958-59, resulting in the chita at page 17. Because actually, if Abul Fakir had rendered evidence that X is my daughter, that will have some value.
Yes, yes, Lordship.
Because the father comes here saying so and so is my daughter, it's a good evidence.
Lordship.
But whether or not the man who was before the tribunal as GW2 is actually Abdul Fakir,
Yes, Lordship.
or Abdul Fakir doesn't know that his name is being used by somebody.
Yes, Lordship.
But is it not strange that Kalu Fakir name never appeared in any voters list? May not be in 1958, but at least 66, 71, 77. This one also. And we can take that. MSK Fukan, learned Renegade advocate, has produced the certified copy of the chita at page 17, which you have examined, and the certified copy is returned back.
Here the petitioner has alleged the order dated 17/2/2017, by which he has been declared to be a foreigner. In fact, the petitioner is the son of Saiful Islam and Saleha Khatun, and the names of his grandparents are Hasimuddin Poramanik and Bilaton Nessa. The Hasimuddin Poramanik's name is appeared in voter list of 1966, which is at page page 20 minutes. 66 minutes. That could be original copy is next page 21 minutes. Serial number 1, my lord. Hasimuddin,
Hasimuddin Paramanik is the grandfather.
grandfather of the petitioner.
This is a list of which year?
66, my lord.
Wait, 66.
66.
Gaon, Sargaon,
Shargaon. Thereafter, my lord, they met
Thana Bagbor.
Tanabag.
So now who is the father?
Father is Saiful Islam, my lord. His
Page.
name appears in the voter list of 1975, my lord.
Page number.
Page number, my lord, 24, my lord. Serial number, my lord, 910, my lord.
24.
24. That my lord, Saiful
Is
Islam.
it the same village?
No, my lord. Actually, my lord, after 1966, my lord, the petitioner's family, my lord, they hail from a Brahmaputra river affected area, my lord. River affected
Mr.
area, my lord.
Your Islam,
Yes, my lord.
Mr. Islam, rather than giving an explanation, show us the material.
In 1966, voter list. my lord,
Understand, you are trying to explain the situation or
Yes.
you are trying to tell what had happened.
Yes.
Instead of going in that manner, show us what material will substantiate.
Yes, but subsequently,
Which material will substantiate that
the-
the family had shifted?
The grandfather of the petition, my lord, had a plot of land, my lord, at village Sutirpa in 1971, my lord. After the demise of his grandfather, my lord, that plot has been mutated in the name of the petitioner's father, my lord. Father along with.
How do you know that it is the same person and not person having same name?
This same plot of land, my lord,
Mr.
they are paying the.
Islam, there are certain methods how you can establish a shifting. You remain confined to those methods. Sutirpam, the names may be same. There may be two different people. How do you know?
Same person, my lord.
Is it your case that there is only one person in this world whose name is Hasimuddin Paramanik?
Hasimuddin Paramanik of the
Understand.
Sargaon.
Are you trying to say that there is only one person
No,
in this
my-
world who has the
that
name
cannot be.
Hasimuddin Paramanik?
That cannot.
So wherever he purchases land, it will mean it is the same person. It is not so. So Tirpam person may be a different person.
Oh, my lord. I have explained my in my petition, my lord.
Under which law an explanation can be substituted for evidence? Does the Evidence Act anywhere provide that an explanation can also take is acceptable in place of materials on record?
So it was village, my lord, the
Please.
petitioner's grandfather is saving a plot of land, my lord.
So Islam, you are free to go ahead, but you are heading towards a dismissal of the writ petition.
I will file an affidavit, my lord.
If you have material, produce it. If you
Yes.
don't,
I'll produce.
but these stories can never substitute.
I'll produce, my lord, by way of affidavit, my lord.
Even in affidavit must have materials to prove. How can you prove a shifting? Tell me. You may show any number of plots of land in different places
Yes.
that I have purchased. How do you know that it is the same person? And that it is not two different persons bearing the same name?
I will file. my lord.
Understood?
Yes, sir.
So name has no value. What you have to show is that they are the same person.
I'll produce. the report.
Unless you bring in material to show that there is only one person whose name is Hasimuddin Paramanik in this world. So even if he goes to USA and purchase land there, it is the same person. Right? Understood why you are
Yes.
putting with this
Yes,
question?
yes.
What do you want to do now?
After 2 weeks, my lord.
What will you do after 2 weeks? It's a matter of 2017.
Yes,
6 years
after
ago.
2 weeks, I will file an affidavit, my lord, annexing some documents, my lord.
What document will you bring?
And revenue record, my lord.
Revenue record.
Revenue
Again, revenue record, whether the man is same person or not, name may be there.
Yes, my lord. The secretary or Gambura will.
Gambura will.
Yes.
Gambura, under what law Gambura will depose?
Gambura or secretary, my lord, they will.
Under what law will they depose?
Otherwise, my lord, he cannot,
Then you face the
he
consequence.
cannot prove his linkage, my lord.
Then you face the consequence. We are passing the order today itself.
After 2 weeks, my lord, I will file an affidavit, my lord, and send some documents, my lord.
Will not allow you to just an adjournment for nothing. You have to tell us substantially what you are going to do. We'll allow you time. What you are going to do, which will actually help us in
Yes,
determining
I
the
will
issue.
produce the report, my lord, whether Hasimuddin of Sargao and Hasimuddin of Sutirpar is one and same person.
What evidence will you bring?
Yes. I.
No, what evidence will
I'll
you bring?
obtain
Tell me.
instruction from my client, my lord. As to how they will prove, my lord.
So now you're dependent on your client to prove.
Yes. Tell me.
If the lawyer cannot prove it, then how can the client is expected to apply his mind and produce material?
Son.
So many discrepancies are
Yes,
there.
my
Lord.
lord.
Understand?
Otherwise, my lord.
Nothing is consistent in this case.
Otherwise, my lord, SP Porpeta maybe, my lord.
Why
affected to-
why will do it?
Was an inquiry, my lord, as to why.
Mr. Islam,
Yes, my lord.
why you will do it? Burden is on you to prove your
Yes, that
case.
is-
So you cannot prove your case, so you shift the burden to the SP to now prove his case.
No.
No, it cannot be. But if you bring any appropriate material which may show that yes, the family of Paramanik had shifted, you definitely entertain it.
Yes, I will produce this.
But what material you have to tell us?
I have certificate, my lord.
You're wasting time, Mr. Islam. Already wasted a lot of time.
I'll take an instruction
See,
from my
again,
client.
6-year-old matter, we can grant you adjournment, provided that on the after, if we grant you time, you'll do something substantial which will help the case.
285 totally.
We cannot allow you time for just for nothing. In
1985
17.
1985 voter list place 33. This is of village Bahati. Again, petitioner is of village lordship.
Yes, see, one is of Sargao, then
is-
they comes to Soisimana,
Soy-
then they
Soy-
come to another village.
Yes, my lord.
Proceeds of another 4th village.
Yes, sir. So many disturbances are there. Lord.
One certificate has been.
So
issued by-
minus stories, you prove your case. Minus stories and explanation,
Yes.
you prove your case.
On Sarvesh Ali Gabura, my lord, he has issued a certificate, my lord.
And what authority Gambura has to issue this certificate? Then, and if the Gambura issues a certificate, will a non-existent fact will start existing from the by virtue of a certificate?
Take instruction from my client, my lord.
Again, you're back to client.
Yes.
As a lawyer, you cannot think out of a solution, but you are going to ask your client now what to do. There are some answers, at least to confer it, Mr. Sharma. He may help you.
একই নাই তো।
He is in bail or he is in,
Lordship, I have to see I have to take instruction, Lordship. Already he was based on bail.
no, bail is there.
Yes,
First you go and surrender before the SP.
yes, sir.
His father, my lord, his father, my lord, he import the passport also, my lord.
Then it is a more serious offense.
Yes, passport also the.
If a man had wrongly obtained a passport,
Passport of the.
it will be another criminal
Yes,
offense against his
the-
family.
Petitioner's father, my lord. It's because, my lord, in the same village, my lord, that plot has been mutated in the name of the petitioner's father. Father. as
Where
well
is the
as-
passport?
Passport is a page 50, my lord.
Page 50.
49.
Place of birth Bohoti NC.
Place of birth, 49.
This is again of which place?
Bohoti NC.
No.
Bohoti NC.
This is a fifth village now.
Yes, sir.
OTNC presently.
Mr.
they are
Islam.
residing in OTNC. After,
Mr. Islam,
yes, sir.
we have already told you, please don't make out stories before the court. You only establish by relevant material, establish the fact, that's all. If you're interested in story, you can ask your client to write a book. There may be people to read it, but your stories cannot substitute evidence in a court of law. So now passport is of another fifth village, you know.
OTNC.
Huh.
OTNC, my lord.
This is the village number 5 we are coming across.
Sashimona and OTNC, my lord, they are that are adjacent villages, my lord.
So Assam and Bengal are also adjacent.
Adjacent.
India and Bangladesh are also adjacent.
No, my lord.
They are adjacent countries. So do you mean to say Bangladeshi man is an Indian?
No, my lord.
The superintendent of police, Kualpara, to cause a thorough inquiry on the antecedents of the writ petitioner proceeding and submit a report before the court. The inquiry is necessary inasmuch as petitioner firstly claims that Hasimuddin Paramanik, son of Horai, of the 1966 voters list of village Sargaon, is the grandfather. Thereafter, it is claimed that Soiful Islam, son of Hasim, of the 1975 voters list of village Choisimana, is the father of the petitioner. Although the name of Hasimuddin Paramanik appears in the voters list of 1970 of village Sargaon, but his name does not appear in the voters list of 1975 of village Choisimana. The Suvarna police to make an inquiry as to whether Hasim, father of Soiful of the 1975 voters list of village Choisimana, and Hasimuddin Paramanik of the 1966 voters list of village Sargaon are one and the same person. The SP to take note that mere similarity in the name should not be a basis to arrive at any conclusion, and a physical verification is required for the purpose. Why do you rely on the 1966 voters list, page 27 now?
Page 27, sorry, 1966 voter list that contains the name of the petitioner's mother's father.
Mother's-
Mandal is the
Okay, Hobi Mandal,
grandfather
mother's
of the
father.
petitioner,
Very well.
paternal
So,
side.
then next reliance is Mr. Sharma.
Lordship. Next is Lordship. 1985 voter ID, page. 1979.
79.
No, again,
Page 31.
thereafter reliance is placed on the voters list of 1979. Here, Agorkhan ki asid. 75. 79 of village Bohoti Sor of village 191 Bohoti
NC.
NC. And it is claimed that Saiful Islam, son of Asimuddin, at serial not legible bracket, serial
70.
bracket not legible, is the father of the petitioner, and that Saiful Islam, son of Asimuddin of 1979 voters list of village Bohoti NC, and Saiful Islam, son of Hasim of the 1975 voters list of village Agorgaon Khan are one and the same person. Then which is the fourth one? The writ petitioner proceeding before this court is Abdul Salam, son of Saiful Islam of village
Budusora Hatkhola.
Budusora Hatkhora.
Budusora Hatkhola.
Sir,
In the circumstance, another verification will be required whether Saiful Islam, father of the proceedings Abdul Salam of Budusora Hatsora,
Hatkhola.
and Saiful Islam referred above of 75 voters list of village so and 79 voters list of village Ikon village are again one and the same person. Further reliance is placed on the passport issued in the name of Saiful Islam, who is the name of the father? No. Passport of nothing.
Hasimuddin.
Son of Hasimuddin of village
Bohoti NC.
hmm,
Bohoti NC.
Bohoti
NC.
NC. Bohoti NC. Is it the 79? Yes, Bohoti NC.
Yes.
Bohoti NC.
Of village Bohoti NC. A passport in the name of Abdul Salam, son of Saiful Islam, is also relied upon, of village Bohoti is also relied upon to claim that it is the petitioner himself.
Yes.
The Suvarna Police Border to also make an inquiry under what circumstances the two passports were issued, to whom it was issued, and whether it was actually issued to the writ petitioner proceeding Abdul Salam. The comprehensive report and detailed report be produced on the next returnable date, which comes so and so. It is the Suvarna Police Border is indicated that while making the inquiry, presumptions on the basis of names in any document shall not be the basis, and the verification report should be actual physical verification of the issue. Based on so and so. And Mr. Sharma, if they are having passport, why were these people referred? Father is having passport, son is having passport.
But petitioner Abdul Salam of Bohoti NC was not referred. Lordship.
Sorry.
Abdul Salam of Bohoti NC was not referred. He realized their document, Lordship.
Acha, now who is the proceeding?
Lordship, do.
No, because that passport contains a photo.
Yes, Lordship.
Is it a photo of the petitioner or it's a photo of somebody else? Verify that also.
He is of village Budusor Hatkhola.
Verify from the passport office
Yes,
to whom that passport was issued and what is the photograph of that man.
Lordship.
Whether it matches with the writ petitioner.
Yes, Lordship.
For the inquiry, the petitioner to make himself available before the Suvarna Border on so and so. You go and appear before the SP. Fixed it. So let the SP take a look at the face of this man first
Yes, Lordship.
and then compare with the passport. That's the first step you do. If it is the same person, then rest of the inquiry. If it is not the same person, then end of the matter there only. Your matter, Madam Dekar.
Lordship. school
Yes, what
records
does
of-
it say?
In the school records of 1989, Abdul Kalam Azad name is appeared, son of Oliullah.
Son of
Oliullah.
Oli.
Mohammad Oliullah.
of which village?
Borchari, Moscow. Jamuna.
So it's okay then. And is the record all right according to you?
Lordship.
Accepted. Mr. Sharma, you also take a look.
Second class, second one. Itna Abdul Kalam. Son of second class.
Yes, now the third paragraph, petitioner to provide any that Oliullah of Borzari Mazgaon and Aliullah of village Ekrapali, they are the same person. What material you have?
There is any document, my lord.
Sorry,
No document, my lord.
then we dismiss the
No.
case.
Class 7 transfer certificate from Mohammad Abdul Kalam Azad আছে। Class 8 or register.
He is setting in manner.
Sorry.
Boundary Mazgaon, my lord.
So we dismiss the case.
এখন স্কুলৰ পৰা transfer certificate আছে। আব্দুল
His
কালাম
father
আজাদ।
purchased the land. my lord.
See, X of Guwahati and X of Dibrugarh, although the name, both the name is X, it doesn't mean that they are the same person.
Also, certificate was issued in the name of Lordship Abul Kalam Azad, son of Oliullah, and Lordship, his father has two names, Lordship Roisuddin alias Oliullah. So is they are same person or not there?
No, where?
Lordship in cost title, Lordship Abul Kalam Azad, son of Roisuddin.
Son of Rohizuddin.
Rohizuddin alias Oliullah.
So who is the petitioner? Abdul Kalam son of Rohizuddin or Abdul Kalam son of Oliullah?
Oliullah.
Not Rohizuddin.
Same alias.
There is nothing called alias.
আব্দুল কালাম
Especially in a foreigner's case, there is nothing called alias. Why you know? Suppose today Madam Dekar makes a claim that I am Madam Dekar alias Madam Tikro. And no, we are not calling you. And produces all the documents of Tikro and say, yes, I have proved my citizen. Will it be sufficient? And merely claim, yes, alias.
My lord, yeah, my lord.
Alias has no meaning in these proceedings. In a criminal case, yes.
My lord, there is a Gawra certificate, but he has been evidence value.
Gambura
Yes, my
certificate has no value.
Yes. But my lord, here, he is holding the charges of Erakopili and Bordari Mazgaon. my lord.
Erakopili and
Bordari Mazgaon.
who?
The
This Gambura.
Gawra, yes, my lord.
আব্দুল আছে transfer certificate
Baki Erakopili means here.
Kindly come to this study.
No, the Gambura to same Gambura, no, it must be adjacent villages. As on Gambura, the people. Also, keep ordinary must come money. Everything. Every કોઈ પણ કામ કરતા હું કોનો ટેકરા પર દીધા પણ એફએમ માં ટીવી નું છે
A and B, two different activities from women which practice and every women respectively one of Muhammad respecting allied Aliullah. The presence of the DW1 claim to be his mother. Something which is very difficult to say, and certain application can help. So, we just have one thing. If you want to reach the money, maybe in perfect economy, that's what he's gonna do.
Much for the revision.
Mr. Sharma, make a verification because the Gangura is one common Gangura, Ekrapalli and Bordari Mazgaon. There is a possibility that this Oliullah, he may be residing in Bordari Mazgaon. His son went to that school, so that address is Bordari Mazgaon. And he may have also purchased the land at Ekrapalli in a nearby village. That possibility is there.
Yes.
Make a verification and submit a report. There is Subandra police border of Nagaon district to cause a verification and submit a report whether Aliullah, son of Jikir Mia, who had purchased a plot of land at village Ekrapalli by virtue of the sale deed dated 28/3/1970, which is available as Exhibit 15, page 90 of the LCR, and Aliullah, father of Abdul Kalam, a resident of village Borjari, as depicted in the school certificate of Jamuna Mugh High Madrasa, are one the same person. We have verified the admission register in original of Jamuna Mugh High Madrasa, and the information confirmed is that Abdul Kalam Azad is the son of Aliullah, Muhammad Aliullah of village Borjari Mazgaon. Heri Khan, sale deed Khan Aliullah, certificate Khan Oliullah. List on so and so for the report.
Published.
Hey, please, sir. I beg to mention on behalf of P. Mahatai, he is an unwell, my lord. Pacemaker installation.
Pacemaker.
Yes. There were 1 week maybe.
Pacemaker problem will be over in 1 week.
2 weeks ago,
Acha, 2 weeks ago pacemaker was put.
installed.
So will you be comfortable after 1
Yes,
week or
sir.
you need some more time?
He informed me.
No,
for
you
1
need some more time or you will be comfortable after 1 week?
month.
Sure.
See.
Ask Mr. Mohanto. Because again, after 1 week, you'll listen, they will also come prepared or instead of adjourning it. Take a longer time, come back healthy, appear before the
He
court.
informed me one.
Informed you.
Yes.
Okay. It is stated that Mr. P. Mohanto, then counsel for the petitioner, has undergone a pacemaker operation. And therefore, the matter be adjourned for a week, pray aloud, list after a week.
Obliged.
What's the matter, Madam Pro, this one? Nagaland
This is,
matter?
With regard to, my lord, the suicide in the
So why is
custody, my
it,
lord.
why is it here?
In the last occasion, you were deliberating.
No, no,
on the-
why is it here in Guwahati? Why not in Kohima?
Yes.
Or
it
you
can
want
be
to retain
transferred-
here?
It can be transferred there.
No,
because
no, we
the
are
court
not,
is sitting
we are
there.
not
If your
insisting,
worship-
but we're just asking.
Yes, my lord.
Or
Can
you
be-
want, or you want it here. If you want it here, we can hear
It can
you.
be transferred, my lord.
Because
may be
But
transferred.
maybe Mr. Mohanto will have difficulty. So
Records,
he may.
records
Records,
also will be there.
no, records are here with
No, my lord, it has not been called. The records also has not been called.
it's a 2018,
2018.
18 matter, yeah,
18 matter,
regarding custodial debt.
lordship, lordship.
Just a minute. It will.
Your lordship, in the last.
No, no,
occasion
Madam
was-
Pro, what we are thinking,
Lordship.
although Mr. Mohanto is not here today,
Mhm.
if there is any necessity of any records, let us call it today only.
Lordship.
So that on the next date, we can take it up when Mr. Mohanto is there. Was there any earlier order of the Lord's Supreme Court to enable the respondent number 12 to file?
Also,
any activity?
yes,
Who is
my
right,
lord.
respondent number 12?
He is the investigating officer. He has filed affidavit today. Actually, we are supposed to file yesterday.
Are you representing him?
Lordship.
You are representing him,
Lordship.
okay. No, regarding sending to Kohima bench, there was an earlier order of Justice Tagia. Since the matter pertains to Kohima bench, registry is directed to verify whether this writ petition has been permitted to be retained in the principal.
Exactly, my lord.
Possibly there some permission is there. So we'll take it up instead of sending it back.
Lordship, in that case, your lordship, if your lordship raises the records may be called.
That's what I am trying to look into. What record to call? Which record?
No, because inmates and all these are.
No, I understand. Which record? If you can help us, we'll pass the order. If you can clearly indicate that this record will be relevant, we'll pass the order. You have the post-mortem report of the deceased? Because stand of the state is that he committed suicide inside the jail premises.
Lordship, this thing is my affidavit for the state. Next, my listing.
Both of you appear for different respondents or same?
Be appearing for the respondent number 12, that is the IO,
Okay, Crow for the IO
my lord.
and you are for the state report. Okay.
So that way, like I mean, see, in my affidavit, I have annexed my magistral inquiry report has been in this thing annexed.
Magistral inquiry report.
Yes, your
Okay,
lordship, inquest report,
inquest report.
and then the WT message and the FIR has been this thing annexed. Thereafter, again, another magistrate report, inquest report, sanction order dated 29/18 and.
Sanction order.
Which is regard to do with this thing.
Sanction for what?
Compensation.
by the
compensation.
human rights. So like 1 lakh, it has been fixed, it has been like, it is still lying in.
And for the petitioner, what do you want? The person is, his died, he is no more. What relief are you seeking?
I am not aware of this matter.
You're not aware at all. Okay. What is the prayer?
Page number 17 of this.
17. Why independent inquiry by a competent authority or the death who projected to commit suicide should not be carried out? Okay. This we will deal with after reading the postmortem report, the inquest report, and the circumstances under which, according to the jail authority, he had committed suicide. Okay. If we feel that the circumstance is not compatible with database suicide, maybe we'll think about some other inquiry or something, whatever is required. If the manner of in which a death had happened is compatible with database suicide, maybe we can take a different view. Second prayer is heavy compensation should not be imposed at the. What is actually heavy compensation? On the particularly the 1.4 ultimately causing that. And on the other hand, if the records give some indication that it may not be a case of suicide but of homicide, then of course we'll have to look it from a totally different point of view. So for the time being, you already have the inquest report
Yes.
and some magistral inquiry report, fine. A second magistral inquiry report.
Yes.
Also produce a postmortem. Postmortem and the CD related to the UD case that may have been registered. In the meantime, the complete records, which may include the postmortem report, the CD of the UD case that may have been registered as a result of the death of the husband of the petitioner, and all other relevant documents as per the discretion of the state authorities be made available report on the next return date.
Lordship, I pray that it won't be to 1 week.
Sorry.
Petitioner has prayed for 1 week time.
Okay, something
but
more.
for me, 1 week.
2 weeks. List on so and so after 2 weeks. Mr. Mohanta will also be more healthier by 2 weeks. That we think.
Right. Would you kindly say last order?
Okay, we have registered a suo motu petition. In view of the suo motu writ petition, we registered notice issued to Abdul Jabbar. Suo motu has not been registered. Oh, Boro. You could register for that, 27 Harry registered for this. Suo motu Harry has not been registered. What do you say? We'll take up after some time. No. Hmm. Directly find the one so much waste. Call for the consultant. সেকশন অফ হয়ে গেছে সেকশনের লিস্ট করার মধ্যে আর লাস্টে কি করে হয়েছে সেকশন প্লাস লিখে দিছে নোট হালকা পাঠিয়ে দিছি রেসি যত দাবো লাগে কেবল জয়েন নেই ফাইলে জয়েন নেই ইয়েস নেক্সট ওয়ান in item 6 or in item 5
Item 5.
in item 5 we don't need your submission as on today. We'll hear you when you take up the matter. Oh. And anyway, 5 will call a little later. Item 6, yes.
Report was what?
Report for report.
Oh.
Have you read the earlier order?
Yes, Lordship.
Over.
Communication made, Lordship.
It will come on the by the book. The order.
Yes, Lordship. I have made the communication, Lordship, but
Not come.
not.
Mr. G. Sharma, Home Department, prays for some further time to do the needful as indicated in the order dated,
Order dated,
the
Lordship,
last order,
26/7/2022.
26/7/2023.
Published.
Yes.
May I please, Lordship? Lordship, petitioner name is Akil Ali and his father name is.
No representation on behalf of the petitioner.
Lordship, it was earlier dismissed on for no non-representation.
But
Later on, it was.
so it has been restored.
Later His father name is Moinuddin Lordship, and I am relying upon voter list of 1966
Page
Lordship.
number.
Page number 13 Lordship, and 14 is a vernacular Lordship.
Page number 13.
13 Lordship,
13.
13 Lordship. Moinuddin or Bheloguri Pathar Lordship.
Hello, Goody Pothar.
Lordship. Jamunamukh, LSC.
Where is the vernacular? Page 14.
Page 14 Lordship,
Nothing is readable.
Lordship. Lordship, that LCR may be called for Lordship.
Why will you call for the LCR after 7 years? We may not call it.
Lordship,
for-
earlier it was called for Lordship, but it was
It was called for earlier.
earlier Lordship.
By which order? Oh, after your case was dismissed, LCR was sent back.
Send back Lordship, send back Lordship.
The writ petition was dismissed by the order dated 3/8/2022 for non-prosecution. As a consequence, as per the office note dated 11/8/2022, the LCR was sent back to the tribunal concerned. Later on, by the order dated 8/11/2022, in MC 10/2022, the writ petition was restored. Consequently, the matter is listed today, but it is noticed that the LCR which was sent back had not been recalled. Call for the LCR of FTD case number 01/2015 from the Foreigners Tribunal number 10, Doboka Naga. This time, dated.
Deeply obliged Lordship. Lordship. That's why in this morning, I am mentioning this.
You are not to mention in the morning these kind of matters. Take note of that.
Lordship, obliged.
Item 9.
May I please, Lordship?
See, Mr. Counsel. When a matter is listed, it has to be taken up when it is called.
Lordship.
Morning 10:30 is only an exceptional circumstance where because of inconvenience of someone, a matter has to be adjourned. And you should learn as a young counsel
Lordship.
and try to make the habit of staying in the court also. Not that one matter is there, 10:30 mention, go back and enjoy yourself for the day. Remain in the courts. Because these orders have to be passed only after looking at the file. At 10:30, we are not looking at the file. That's a difference. And you are trying to now put the blame on the court. I made a mention at 10:30, same order. Take care of your conduct also. Improve yourself. Yes. Yeah, what's the name of this man? Ask his name and tell the name of this man. Yes, sir, Mr. S.
May I please, Lordship? No, here petitioner is Momtaz Begum alias Momtaz Begum.
Sorry,
Momtaz Begum alias Momtaz, Montaz.
Momtaz alias Momtaz.
Momtaz Begum.
Okay, actually what? It cannot be alias. It has to be either Momtaz or Momtaz.
Momtaz actually.
What is the correct
Momtaz,
name?
Actually Momtaz, my lord, but
Huh.
in some documents her name has been recorded as Momtaz.
Momtaz.
In place of M, N has come. Momtaz, Momtaz.
Okay, now please argue who is the father?
Yes, my lord. Fathers, my lord, father,
Required by the order of 16:3. 16:3 something is there.
my lord. My lord, father's name is Surja Mia, my lord.
Refer to the proceeding relies upon the voters list of 66 of village Kismat Moinbari,
Yes, my lord.
Babur. In the name of Surja Mia, son of
Mia.
Naya, petitioner. Surja Mia is the father.
Father, And
relies on the
Dali
certificate of the Gaon Panchayat. It appears that there is a variation between the village in the voters list and the village indicated in the certificate, which is also. Yes, certificate is of which village? Khondakar Para. And voters list is of village?
village Kisamat Moinburi. That is,
Kismat Moinbari.
yes, she married to my lord, another village.
Huh. So after marriage, she goes to Khondakar Para.
Yes.
And before marriage, she was the of Kismat Moinbari.
Moinburi. That is his.
So then why you get a certificate of Khondakar Para, get a certificate of Kismat Moinbari, that you are the daughter of so and so.
My lord, in the LCR, my lord, one Gaugura certificate is there, my lord. That is page 32. Perhaps
What does
that
it-
is from Kisamat,
What does it say?
Gaugura certificate. Page 32 in LCR.
Mumtaz Begum, daughter of. But this will not be sufficient. Any other document to prove
Oh, my
your
lord.
marriage register, Kabin Nama, school certificate?
It is my lord, last occasion, my lord, I asked my lord her. She, my lord, not.
She never got married, she never went to school. Then how she is in India, another village with another person?
Yes.
Their marriage must be there. Marriage must be with a Kabin Nama. Marriage must have been registered with some authority, either the government Qazi or private Qazi. Qazi is I think Qazi is mandatory for a marriage. Yes, Mr.
That is
Islam.
not
Can there be marriage without Qazi?
Yes, yes.
Yeah, how? Sorry.
Other Munshi can done, Molavi or Munshi can done.
Does he maintain any record?
No, my
No,
lord,
my lord.
that is not.
Only registered Kaji, government Kaji.
No, then how would a marriage will be proved? Suppose a person gets married in this manner.
My-
Tomorrow the person said, no, I never married this person. How will you prove it?
Possible, my lord.
How?
If record is not available with him.
No. How will you prove it?
Normally two types of Kaji maintain record. One Kaji, my lord,
We are not on that. Suppose the marriage you are indicating,
my lord,
one Molavi will do it.
my lord,
Suppose X marries Y in that manner.
my lord,
Next day, X feels that I was not married.
my lord.
Suppose he claims this thing, I never got married. This marriage never took place. How will the parties prove the
In every
marriage?
marriage, three witness required.
Three witnesses.
Three male.
So now in this marriage also there must be three witnesses. Who were the three witnesses?
Maybe it's
Maybe the villagers, my lord, or
some
my lord, relatives.
elder person, my lord.
I understand. Find out who are the witnesses to the marriage.
Yes,
Their evidence may be of some relevance.
yes.
Otherwise, how will you prove it? If the existence of a marriage, what Mr. Islam says, can be proved by virtue of the three witnesses to the marriage,
Yes.
the three witnesses can also give evidence as to whose daughter this person is.
My lord.
No, Mr. Sharma, that can be done.
Yes, Lord.
Do it.
Fine.
All right. No. এইটো কিবা এটা সুমতো ৰেজিষ্টাৰ কৰিব ষ্টেচন দি পঠিয়াইছে নাথিং ইজ ৰেজিষ্টাৰ এই সেইটো এজন to be listed and the matter be brought to the notice of the registered judicial মই সাধাৰণতে এনেকুৱা অফিচত নিদিয়ে তো কোৰ্টে কৈছে ৰেজিষ্টাৰ কৰক কোৰ্টে অফিচত দিব দিছে নট ৰেজিষ্টাৰ্ড সুধিবচোন কোনে দিছে এইটো One that gave that note and sent back to the court, but he was. 2 weeks. 2 weeks. But ask that person who had given that note, why did he do it? No, ask him initial who it is, why did he do it? Because that man was aware that there is a judicial order. His duty was to take it to the registered judicial, point out. Instead of doing that, he sends it back to the court, not registered. So is it a defiance? It's a contempt. You take it at your own level, ask him, and not to do all these things. So do that. Otherwise, how do you prove your case?
My lord.
But do we have any further material?
Further, my lord, some.
Yeah, what about this person, your father? What's the name? Surja Miya, father. Is he still alive?
No. Father, mother. No.
Mother also died.
Yes.
Can you prove?
Also, before the inquiry officer, Lordship, perhaps he did not furnish the name of his father, Lordship.
Page number 9 of the LPR.
They did not furnish the name. Why did you tell the name of the father? They would have made an inquiry. Hmm. 17 matter.
Lordship. Lordship.
What is to be done? What do you want to do, Mr.
Remand back the matter, my lord, to.
Remand under what law? Is there any proposition that under 226 on an asking the matter will be remanded back without any reason?
Otherwise, she has no other documents, my lord, to prove. At
Then
this stage,
we dismiss the petition if you are saying she has no document.
At least, my lord, she'll prove her marriage by.
If she can prove her marriage, that is, if she
The Petitioner may produce any relevant material which may prove her marriage. And such material should indicate as to whose daughter the petitioner is. Wait, if you can.
Otherwise, no option. Lord.
Sorry.
Otherwise, no option. Lord.
Obliged.
Mr. Islam, please help Mr. Ahmed see what can be done.
Apology for the conduct, Lordship.
Sorry.
Lordship, apology for.
No, apology is okay, but that's not a very good thing. You made a mention at 10:30. And going by your mention, we can make out that we need the file. When you need the file, we don't allow mention. It has to be called. The mention is only on one line adjourned, that's all. And at the end of the order, when we did, then you are raising an issue. I made it at 10:30 itself.
No, Lordship.
So that means
Apology.
you're raising a questioning the court. Why didn't you allow the adjournment at 10:30? Is this a good behavior of a council?
Apology, Lordship.
And everything we do, we follow a procedure. And it is uniformly applicable to all.
My lord,
Yes, please.
page 10, my lord. Page 10, para 4, my lord.
Page 10.
Page 10, para 4, my lord.
4. What is it?
Can you see, my lord, see the order, my lord, how it was passed, my lord.
No, order we'll see. First, you discharge your burden that you
Yes.
are a citizen.
For the foregoing reasons, I hold this 27 OP to these 27 cases more perfectly applicable against
Mr. Rahman,
foreigners.
instead of criticizing the judgment,
Yes.
you discharge the burden that you are a
Yes,
citizen.
yes. Ex parte, my lord.
It's an ex parte order.
Ex parte order, my lord. At page, my lord, page 9, my lord, clearly mentioned.
Mhm.
Second para, my lord. The reports of the serving officers on the notices are all same. And these disclose that that no school purpose will be served by reissuing notices to the opposite parties.
What is the report?
The reports of serving officers on the.
No. What is the report, Mr.
My
Sharma?
lord, they have report, my lord, they have submitted, my lord, witnesses. They have taken signatures of witnesses, my lord. Witnesses of the localities. And it is as a result, my lord, expert order was passed.
Just check up what happened in the service of notice.
In judgment, my lord, is mentioned, my lord. Signatures of respectable witnesses of the localities. My lord.
Let us see what actually happened. Why notice is not served?
I think
Can any fault be attributed to the proceeding, or it is the person serving has not done the needful what is required to do? That is no cost to arguably, if the person is deliberately avoiding it, he cannot take advantage of that. It already said. If you are 27. 27 now respective last case about of these 727. Why it is 27 OPs?
My lord, there were, my lord, 27 my lord, proceedings, my lord.
Why?
And I am one of them, my lord. That's what, my lord,
It's a matter of which year? 2000.
2008, my lord. Judgment was passed on 18/3/2008, my lord. And in the judgment, my lord, it was clearly mentioned the serving officers concerned observed all the required formalities by securing respectable witnesses, my lord. Of the localities, my respectable witnesses of the localities. In the judgment, it is mentioned, my lord.
Let it be. Let us see what had actually happened. Check out what had actually happened. What is the report of the process server? Find out. Ini juga tahu. Apa start tu? Combine reference one or have the one or.
I noticed that. I have not noticed it.
Separate reference registered code. Mr. Raman, we'll do one thing. All 27 to go and appear before the tribunal on a given date.
My lord, I am for only one, my lord, proceedings, Saleh Ahmed, my lord. Your lordship will direct, my lord, that my lord, I'll comply.
Then let us do one thing. We direct the SP border to take into custody all these people. All that.
My lord, we were in custody, but we are released during Corona.
Understand, they will be retaken to custody, produced before the tribunal on a given date. Tribunal will issue notice and they will accept notice before the tribunal.
My lord, that can be done, man. But my lord, that for 3 years we are in custody.
You
We are
remain,
released on, my lord.
and the tribunal will take a decision whether they are to remain in custody or they are to be released.
Yes,
My lord.
So that this business of not serving notice for the last 25 years comes to an end.
My lord, my lord.
Otherwise, you will spend another 50,
My lord,
25
That
years.
can be done, my lord.
Just play the same game.
My lord, that can be done, my lord.
You heard Mr. SSS
My lord,
Raman and counsel for the petitioner also. It is noticed that. No, this petition is instituted against. It's not a judgment. How can a tribunal call it to be a judgment?
it should be opinion. Lord.
Order. It's not even an opinion also.
Please,
Order dated 18/3/2008.
page 8, my lord.
In foreigners case number, where is the case number?
On a case number, my lord, FT 29 of 2005, my lord.
In FT 29 of 2005. Of the foreigners tribunal, Sibsagar, there is only one or 1, 2, 3, those numbers are there.
Only one, my lord.
Of Sibsagar.
Jurhat, my lord. Jurhat now, my lord. Amalgam.
Sibsagar, Lord,
No foreigner tribunal now.
Separately, it is not there, which is presently serving
and Jorhat.
at Jorhat. The reference was registered against 27 different persons, namely, give a list of the names of these people. One only.
Page 8, my lord.
Page 8.
Page.
Can you type it out in a piece of paper? Give it.
My lord, I can.
Or namely so and so. The tribunal in its order dated 18/3/2008 had provided that in spite of all the efforts being made to serve the notices, the proceedings could not be found, and as a result, notice were served in the presence of certain reliable witnesses. Having accepted the service and notice, the order dated 18/3/2008 passed, which is an ex parte declaration that all the 27 persons are foreigners.
My lord, the order is 18/3/2008, man.
2008. That all are foreigner. Being aggrieved, one of the proceedings, namely Saleh Ahmed, has approached this court by way of this writ petition. On one hand, it is noticed that the procedure of notice adopted by the tribunal may not do complete justice to the proceedings, to result in an ex-party declaration that they are foreigners. At the same time, the conduct of the proceedings also cannot be appreciated that for almost 20 years now, they have evaded service of notice by the petitioners, resulting in the order dated 18/3/2008. In the circumstance, the Superintendent of Police Borders Sibsagar is directed to take all the aforementioned 27 proceedings to custody and produce them before the Foreigners Tribunal Sibsagar at Jorhat at a fixed date of video on so and so. The 27 proceedings upon being produced before the tribunal, the tribunal shall firstly register 27 individual references against them, and in the presence of the proceedings before the tribunal, the notices be served upon them, and thereafter a regular proceeding against such proceedings be conducted by the tribunal. Regarding the necessity of keeping the petitioners in further detention upon being produced, the tribunal shall take a reasoned decision on the same and pass appropriate order. Accordingly, the order dated 18/3/2008 in so and so is set aside. Full stop. The proceedings are also directed to cooperate with the authorities so that the reference against them can be brought to its logical end as per law.
Copy of the order.
My
A
lord,
copy of the order to Mr. G. Sharma, Home
my
Department.
case, my lord, my personal, I will appear on this.
You will appear
My lord, I will on.
and therefore
1st of September,
take
my
into
lord.
custody. They plan to change. But however, Mr. S.S. Rahman and counsel for the writ petitioner Saleh Ahmed
Yeah, license.
says that the said proceedee will voluntarily appear before the tribunal on the given date. Accordingly, in respect of Saleh Ahmed, there would not be any requirement to take him into custody for producing before the tribunal. But on the other hand, if the Saleh Ahmed does not voluntarily appear before the tribunal on the date we indicate about,
My lord.
the Superintendent of Police Border may take him into custody
My lord.
for production before.
Obliged. Yeah, please, the lordship. Documents to prove. My lord, here in this case, my lord, by previous order,
A John on the prayer of Sikdar to enable him to examine for the record a receipt, the English translation of which page 29, which is shown to be dated and pertains to village Ghugubari,
my lord.
page
That-
29.
Page 29, my lord, the revenue paying receipt of 1970, that original we have got, my lord. Condition
Page
is not good.
29. You have got the original.
Original, my lord. Yes,
Because this one you cannot read anything.
my lord.
Senior junior given. So whose name appears here?
Soimuddin, my lord. Soimuddin
Soimuddin.
is father,
Soimuddin
And-
father.
and the father petitioner is
So you rely on page 30
my lord.
to show the existence of Soimuddin in 1970.
70,
That is the purpose.
my lord.
Okay, now.
My lord, there is a land settlement order, lordship will find at page 27, father's name. It is said, perhaps this is the, in respect of that land, my lord.
So Soimuddin Sheikh, son of
The-
Daworu,
Father,
he is there in
grandfather Daworu.
1977.
Yes.
Ghugubari. Before that?
my lord, this land settlement order, lordship will find
No,
at
no,
page
before 77.
My
does he have any
lord,
voter?
they have no voter list, my lord.
No voter list.
No voter
So you
list.
rely on this revenue
Yes,
paying.
The NRC is there, but NRC may not be needed.
She is somewhere. Where is it provided? NRC not admissible?
My lord, in my lord, division bench judgment of this on court, my lord, in Muslim Mandal's.
Okay, it is there.
Yes, my lord. Division bench judgment.
NRC did you know why? Any reason why NRC is not accepted?
Yes, Lord, there's some judgment that I can provide.
No, why? What is the what is the reason?
Because Lordship, reason was also there in that judgment, Lordship. I can provide Lordship.
It is not based on acts, but it is a, my lord, circular, census circular.
Doesn't matter. Is your mutation
That
order
was the
based,
reason given, my lord.
is the mutation order based on act? No.
No, my lord.
Is your school certificate based on any act? No. If they are admissible, why not the NRC? NRC not
think
claiming it
that-
is right, but the NRC will at least show the
Yes.
existence of that
Yes,
person.
my lord.
Otherwise,
think-
it is a not a final document, Lordship. That's why. it
May
is
not be a
to-
final document.
Yes, sir.
See, NRC cannot be adopted to declare citizenship of a person because it is not a statutory provision. It is not a final document. We understand that. But for the limited purpose of whether the person existed as on that date,
Yes, sir.
why it cannot be taken? Moment the name of a person appears in NRC of 1951, it shows that at least that man existed. Whether he has the status of a citizen or not, that is another factor.
Lordship. I can provide the judgment, Lordship.
No, we don't want to reopen all these issues. If
My
we
lord.
settle it, let it remain. But otherwise, logically,
Yes,
we are asking you,
Yes, well, it's lordship is correct, my lord. That's it.
if you accept a
Existence.
mutation order, if you accept a sale deed is not
Yes, sir.
under any statutory provision. Why do you accept a sale deed? A man purchased or sold the land as on that date means that man at least existed
Lordship.
on that sale date. These documents are for the purpose of establishing the existence of a person. In a sale deed, we don't determine whether the land, any land right had accrued or not.
Lordship.
Sale deed we only rely upon for
Existence of the
existence.
person.
same with the NRC. NRC we are not relying upon any further right.
Even if, my lord, this revenue being received and this settlement order is
Suppose
considered.
this one only you are produced.
Yes, my lord. It cannot be declared as a post 71, my lord.
No, cannot be declared. No, at least this one shows that this man existed on the said date and he went and paid the revenue,
My lord.
land revenue. Only for that limited purpose we are accepting it. We are not venturing into a question whether the land is your land, somebody else's land, whether you have right over the land. Those are not the issues before us. So only this one. Yes, Mr. Sharma, what do you do? From 77 onwards, there is a voters list
Lordship.
in the name of Soimuddin. And 77.
Yes, my lord, with father.
But before that, only 1970, he paid some land revenue.
Before then, only NRC document is here, Lordship, which is of different place. And Lordship,
NRC, so page 23.
yes, Lordship.
Soimuddin, father's name Dobori. That 77 voter list also Soimuddin, son of Dobori.
But village is different. Lordship.
Acha, village, maybe.
And Lordship,
Jenekura.
Jekinipura, my lord.
Jekini.
They are facing, they were facing erosion and therefore, my lord.
This is what we are saying, Mr. Sigdar. That is an explanation. Explanation has no place in evidence.
Yes, my lord.
and another voter list is there, Lordship, at page 48. Turn out there.
That believe my
You
lord.
will-
Paternal cousin. Paternal cousin.
Paternal cousin.
Who is the petitioner?
My lord, petitioner is my lord, he is Mazam Ali. 77 brutalist, he is with father.
77, he is with the father.
Father, my lord, page 25.
Mazhavali, yes. And who is the proceedee, writ petitioner?
My lord, Mazavali,
Of which village?
my lord, village Guguvari.
Same village.
Yes, my lord. 70, my lord, since 70, they are all along in Guguvari, my lord. At least, my lord, if your lordship consider the revenue paying receipt or the allotment order, then, my lord,
What allotment order?
there is an allotment order. my lord.
Page number.
Hmm? My lord, at page 27. Vernacular is at page 20.
It's of the year 2005. When certified the petitioners and
This is certificate.
Allotted land of Kortiga, suddenly when there was erosion took place in village, many similar by Vicky River, he was permanently allotted Kortiga in village Kuguri. The allotment of the plantation come to village. Mr. Sharma,
Lordship.
come to page 27.
Yes, sir.
See, here it is certified thereafter petitioner had been residing on the allotted land of 4 big heads, Gugurivari, where he was rehabilitated in 1771.
Yes, my lord.
Do you have the records of the allotment? If you verify the records of the allotment, if actually this person was allotted,
Yes, yes.
then it can be linked up to it. At least he existed in 70.
Yes,
yes, yes.
From wherever he may have come from, at least he existed in 70. And maybe those records may contain that he earlier resided in many similar. If a record of 1970 shows he earlier resided in many similar erosion, then allotted land here,
Yes, yes.
we can accept that information. The records of the allotment of 4 big acres of land at village Ghugubari, with reference to the certificate issued by the circle officers, which is available at page 28 of the petitioner,
Page 27.
be produced before the court for its examination on the question as to whether it contains the name of, not Mazamali, it has to be the other one, father.
Father, Saimuddin.
Contains the name of Saimuddin, son of Doboru, for the purpose of allotment. And if possible, from where Saimuddin had come from before the allotment. A list also, a copy of the order, Mr. P. Sharma.
Along with my lord, copy of writ petition.
Writ petition copy also, so that he can. The case number was there.
My lord,
Page 20, refer for you, immediately side of.
29, I will, my lord, laminate treatment. Condition is very bad, my lord. Yes, my lord.
No, you take it back.
Yes, my lord.
Come on, like it. Come on, videographer.
Deep level interest.
অকমান ইফালে গলি যাব চিঙি মানে কোনো মতে লাগি আছে
May I please, your lordship? My lord, page 18 is the brutal list of 1966.
Index করি পড়ে গেলে এবার দিছে থেকে কেন বিচারছে তো এগুলো যদি না থাকে many things ini mereka portfolio apa itu portfolio yes
My lord, page 18 is the brutal list of 1966.
page 18
Yes, lordship.
kitab devani
Quran Ali is the father of the
Quran Ali father
father. Kitab Devani is grandfather, lordship.
Quran Ali father kitab devani grandfather village is Tukrapara
Yes, lordship.
and now
And
who is the petitioner
petitioner Rup Bhanu.
Bhanu which material
Lordship, Kitab Ali deposed before the learned.
Kitab Ali.
Yes, lordship. Father.
Quran Ali is-
Quran Ali.
where is Quran Ali
Yes,
evidence
lordship. Page 59. Cross is at page 67.
where did he say that Rup Bhanu is his daughter
Yes, lordship. Page
where is the line where he stated that Rup Bhanu is his daughter
Yes, lordship. Page 59,
Hmm.
para 4, lordship.
where
That I was born about,
where is the line Rup Bhanu is my daughter
and my daughter got married.
his daughter got married
My daughter.
Ah. his daughter got married we have no difficulty accepting but where is the line that Rup Bhanu is his daughter
My daughter, second para, lordship. Second para, lordship.
Second para.
Second
That
para.
I am a citizen
Citizen.
and
of
that
India.
my daughter Rup Bhanu
Yes, lordship. Maybe Rup Bhanu.
is an inhabit is no and declared that the allegation made upon my daughter allegation is false
Yes, lordship.
he making a declaration and who is making allegation no one is making any allegation if they are making allegation the burden would have been them to prove it they are not making allegation they have only doubt once you have a doubt a person is referred once a person is referred person will have to prove it section 9
Yes.
no allegation
Notice says, it is doubted that you have come from so and so.
the notice is not an allegation notice is a information
Yes.
that one proceeding has been initiated against you you are notified go and appear
You are doubted as foreign national.
no
That-
notice
also it is there.
notice is not an allegation notice of a court summoning a person is not an allegation notice is that a reference had been made against you
Proceed that line.
why is the reference made for an adjudication whether you are a foreigner
Yes.
so there is no allegation by anyone as they do not know whether you are a foreigner or not therefore this proceeding is initiated so where is the allegation
Actually, this is the pattern actually they use to.
while you pattern will not convert something to a fact
Yes. But that line.
so
is there, lordship.
ultimately Mr. M.I. Hussain will have to interpret your affidavit and there is no provision under the law to interpret facts law interpretation facts establish
That line is dear lordship, that she is my, Rupano is my daughter.
Where is that line?
Uh,
You cannot pick up one word from a sentence and say this is the line. Sentence has to be one complete.
that's right.
Rup Bhanu is my daughter was good enough. So ultimately, you are asking us to interpret an affidavit by this person. That this affidavit means that.
Yes,
That cannot be done. No court can interpret facts.
yeah, in cross.
Documents can be interpreted.
Yes, lordship.
Say, suppose it's a sale deed. Court can look into the interpretation whether it is a sale deed in respect of something, some land or some who had purchased and all. But when a fact is sought to be established by means of an affidavit, it is either established or it is not established.
Lordship, in cross, he says that
We had noticed that. Page 67.
68, lordship,
Hmm.
last part, it is not a fact that opposite party is not my own daughter. That line-
This is a suggestion. They
Suggestion.
doubt it.
yes, lordship.
They doubt it. They have done the right thing.
But he is also, he has.
So that is
clarified, lordship.
not that you have established. You have just and what is a suggestion in cross-examination? What is the legal effect of a suggestion? Why suggestions are made? In cross,
Yes, lordship.
you must have crossed a number of people in different proceedings by now. Why do you make a suggestion? What is the legal implication of a suggestion?
For clarifying what he has
No.
stated, lordship.
Suggestion is made to rebut somebody says. He gives an evidence, says that I am a rich man. If you want to rebut that, you will make a suggestion. No, you are a poor man. That suggestion, he'll reply it, say it is not a fact that I am not a poor, not that I am a poor man.
Yes.
That's how it is recorded. Meaning thereby, you have questioned his evidence. So here they are questioning you. You have not established.
Otherwise, lordship, they could not write it in a proper way.
No one prevented them from writing in proper
Yes,
way.
lordship.
The lack of knowledge of the person writing it cannot be a basis that a fact has been established.
But it is a fact that father.
Ultimately, you are asking the court to please interpret my evidence. That is not permissible in law. Law can be interpreted, or the provisions of a document can be interpreted. Suppose today I accept your contention. Tomorrow, in a murder case, prosecution could not prove it. Then come to the court and say, please interpret this evidence that we have presented and come to a conclusion that he had committed a murder. Can we convict somebody? No. How the reverse is possible? What to do?
Lordship. Proper sentence, proper word.
Hmm.
They could not use proper word or proper sentence.
This man possibly tried to mean that only, but he's not
Yeah, express
done
proper.
so in expressed words. The lawyer must have written it that way. He had signed it. That's all. Send it back to allow him to give fresh evidence, because this one we cannot accept. That's only না আর কি করবো এই করোনাদি immediately call for giving fresh evidence. So it was true. Initial observation that although this evidence is thought to be relied upon to be evidence to establish the source. What's the age of this person?
57, 50.
57. And proceeding?
Age of this person, father.
Father must be
Yes.
more.
Yes.
Father is
but-
32 in 66.
Yes, and here it
So
is
66 from now
83.
onwards, it will be almost 60 years. From 1966 to it will be 57 years. So 32 plus 57 is 87.
Yes, here it is 83, written in the year 2017.
Okay, 83. So now it is 30, around that much. Is he still alive?
That I have to.
Rupanu 57.
Yes.
What we intended to do, retaining this evidence will allow him to give further evidence.
Yeah.
If he wants to state in explicit words that Rupanu is the daughter, which is in the opportunity given to further evidence, if anything is stated in conflict with the earlier evidence, you'll be free to cross. And the tribunal will also take note of the conflicting statements.
Lordship.
and the implication of law will follow. And you can further cross-examine him on whatever he states.
Lordship.
And also on the identity of the man, whether he's actually Quran Ali or not.
Yes.
Or somebody else has come in claiming to be Quran Ali and giving this one. Verify all this.
There is no material is available.
Otherwise, no, because why we are doing this? We can dismiss the petition. But what will happen is actually she is the daughter of Quran Ali. And Quran Ali was already before the tribunal to give evidence. Only thing, the lawyer who prepared the affidavit had, being unaware of the law, had written the affidavit in a different language. Although the meaning is possibly to mean that only. Mm. And after this evidence, they pass a fresh order, taking note of all the earlier materials produced.
Yes.
Hmm. Name of husband and husband. From here, you cannot determine. Hmm. মোৰ ছোৱালী কোন মই প্ৰুভ নকৰিলে বেলেগ কোনে প্ৰুভ কৰিব বা মাকে যদি প্ৰুভ নকৰে কিন্তু লিখিছে এনেকুৱা ধৰণে get the information whether Quran Ali is still alive or not.
Yes, Lord, I can take the information in.
If he is no more, again our order will be unimplementable order.
I'm just taking right now.
Seriously?
Oh.
No more.
3-4 days back.
3-4 days back.
Yes, Lord.
Had you heard the matter last week, you would have got the order. What to do now? Yeah, I thought because he'll be nearing 90 now.
Yes.
What to do?
Any marriage document can prove Lordship.
Any other document?
Regarding marriage Lordship.
The petitioner to explore the availability of any further material which may show that she is the daughter of Quran Ali, who is the son of Kitab Diwani, and whose name appears in the voters list of 1966 of village Tukurapara. This is the difficulty of not doing the cases at the earliest possible time. It's almost a 5-6 year old matter. Had you had done it earlier, it would have been very safe for you. See marriage document, school document. Yeah. Or else what can be done? Can we accept that affidavit?
No, no.
The father had made, actually the father had meant that only.
Yes, Lord.
Only thing, the person who prepared the affidavit did not write it in explicit words.
Yes.
In all indirect words. Indirect words is not evidence. Because if an evidence by a witness, we adopt the principle of interpretation, this will be applicable in every case.
Yes. Yeah.
And tomorrow, those criminal cases, there will be a big danger in those cases. All your accused will have difficulty. And everybody will be cursing Mr. M.I. Hussain, why he obtained this order from the court for one matter. Mhm. Because convictions will become very easy then. Only interpret the evidence.
Yes.
That yes, he must have meant this only.
Language of the council.
Understand, we have to read the language only.
Lots.
We don't have to read anything else. This is what I'm trying to tell you. Yes, we can do it. And also adopt that, yes, this witness must have meant that only and nothing else. But moment we pass this order, are we not interpreting this thing, evidence?
Yes.
And that principle of interpreting an evidence will become squarely applicable everywhere. What will happen if in a criminal case an accused, the prosecution takes advantage of it? A case which otherwise would have led to an acquittal will now lead to a conviction because the High Court held that it can be interpreted. And the interpretation is meant that, yes, our witness meant that only, that he had committed the murder.
May I pray one thing? As the father of the petitioner died just 3-4 days back, Lordship.
Yeah, can you bring him back?
No,
Yeah, if you can, you make an attempt to, we won't stop you.
Lordship may.
Is there any order of recall?
Lordship,
Filing a petition somewhere else, that a person may be remanded back for a few days to give evidence and then you come back again. You cannot do it. What do you want to do?
Lordship may send back the matter in
No.
the way Lordship is thinking.
This is what we are difficulty. We cannot send back the matter only for the purpose of convenience of a person.
With that observation. Lordship,
Pending
that
the matter is a very serious affair.
with
If
that
we
observation.
casually adopt the procedure of sending matters back, none of the litigations will ever come to an end. Indiscreet manner, if we just go on sending matters back, that also we cannot do. We thought about your problem, Mr. M.I. Hussain.
That observation may be given that the order may not be considered as precedent in other cases. That observation.
That also cannot be done. Anyway, we fixed it yet. Think about what more you can bring.
Lots.
Or maybe if you can bring in some other material which will corroborate the evidence of this father, then the evidence of the father can be given a different meaning vis-a-vis the other material. But without any supporting material, you cannot give a meaning of its own, which it does not contain.
We can bring some other person, entirely person also.
Do whatever you do. You use your legal acumen, find out your solution.
All right.
Yes, Mr. Islam.
Please, your lordship. My lord, by order dated 8/6/2023, the SP border Barpeta was directed to make an inquiry.
That the Mokale Azam, no different.
No, my lord, it's a Korimun Nessa. Korimun Nessa existed in 1966. my lord.
Department. Whether Korimun Nessa settled of the world 66. But, as well, yes. Are they same or different?
So they are saying same person, but
If it is same, then we pass the order.
but
It is learned. From where did he learn?
Yes, Lordship, it is why I'm saying.
Peruse the report of the Superintendent Police Border Barpeta, which says that it is learned that the Prosidi Kariwan Nessa, wife of Abdul Kader, village Isapur, also appeared in the voter list of 1966. Full stop. Of where is a wide 42 number of Hoyapuri SC. The purpose of the inquiry was as to whether Karimun-Nessa at serial 203 of voters list of 66 of village Kusbari, as well as that of 1970 of the same village, and the writ petitioner Karimun-Nessa are one and the same person. The report is short of making an inquiry on the question raised. A fresh report be submitted.
My lord, I may be allowed to one affidavit, my lord. So, elder person is related, her related. my lord.
No, let this one come. As we have already ordered an inquiry, we can't just brush aside the inquiry and go somewhere else. It is also advised that the Suvarnabhumi border not to submit a report based on what had been learned. Rather, the report should be on the basis of what actually it is.
My lord, I may be allowed to point out one thing, my lord, page 69, my lord. Basically, they discarded this document as not a, my lord, certified copy.
Which
My lord,
document?
Page 69, my lord, last
Which
sentence.
document?
My lord, annexer, my lord, 8, that is, my lord, page 53.
What is it?
Is a my lord certified copy of voter list 1966.
That will take care. Certified copy cannot be rejected. We'll take care.
My lord, only this, my lord, rejection is ground of rejection.
But you have to discharge your burden now before you stop. Next that you point out, we'll correct that. A certified copy cannot be rejected. And certified copy need not be proved also.
My lord.
Yes, we have to prove করবে না লাগে এখন। List on some date will be there. What date one, Mr. Sharma?
Lordship. 2 weeks, Lordship.
Give me the date fixed.
Highly obliged, your lordship.
Hey, SPs are too casual in giving reports.
Lordship.
Tell them, even we have material, same material before us, and we can also take the same conclusion.
Yes.
Only difficulty whether our conclusion will be right or wrong. Therefore, we need you to make an inquiry.
Yes, Lordship.
We don't need a delegated authority to form a view which we can also form. Is it?
Yes.
What they are doing now, the court does not even understand this thing. Let me clarify. It is so and so.
In some cases, I have
Inquiry
already-
means inquiry,
Yes, Lordship.
not what is learned or what he understands.
Yes, Lordship.
Tell them the courts are equally competent to understand. So we don't want to report what it means. We want to report what it is. Yes. Or else like the other SP,
My lord, the page 39,
item number
14. my lord.
14. 39, what is it?
My lord, page 39,
39.
my lord. Um, 39.
Hmm.
My lord, this grandfather name is Abdul Sheikh and grandmother Sabi Bibi.
Hmm.
And my lord, this my father name is Koimuddin Sheikh. Next page, my lord, 40.
Page number 40.
40, my lord. Koimuddin Sheikh, my father. And my lord, Shokir Jan Bibi, my mother.
Just a minute. Abdul Sheikh is the
My grandfather.
grandfather. Sobi Bibi grandmother.
Grandmother. Next page, my lord,
Not next page, come to page 41.
my lord.
Yes.
Take the vernacular one.
Yes.
My lord. Abdul Sheikh, grandfather,
Sobi Bibi, grandmother. Then
grandmother. Koimuddin Sheikh, father,
Koimuddin Sheikh, father.
and Sokir Jan Bibi, mother.
Sokir Jan, mother. Okay,
Mother.
very well. Now, which document will show
Thereafter,
Gulbhan is the daughter of Koimuddin?
thereafter, my lord, my brother, my lord, elder brother, already examined, my lord, DW2, my lord. Finally, see page 48, my lord. Thereafter, my lord, the
Mr. Counsel, where is the missing link?
link, my lord, this
Not link.
register Kabin Nama, my lord.
Where is the missing link? How do you know that that man is your brother?
My lord, this is the voter list.
Which one?
Page 48, my lord.
48. Say that first. First, you establish that the man is your brother and then say what he says.
My lord. Page 48.
40.
8, my lord.
Go to the vernacular one.
Vernacular, my lord. 50, my lord.
50.
My lord, Koimuddin, my father,
Koimuddin, father, yes.
Sokir Jan, mother, Sokir Jan, mother, and my lord, Abul Hussain.
So who had rendered evidence? Abul Hussain.
Abul Hussain, my elder brother.
Okay, fine. Where is the evidence?
Evidence, my lord, DW2 page 129. 129, my lord, and 130, my lord, he says, my lord,
Page number
129, my lord, DW2, Abul Hussain.
Page number 129.
My lord. Annexure 27. DW2.
Affidavit, Abul Hussain.
My lord. And my lord, this second page, 130, in the paragraph 3, my lord. He says, my lord, we are 4 brother and 5 sister, namely Bilati Bibi, so and so, and Golevan Bibi. Golevan Bibi is the proceeding, my lord, petition.
Read the first, second paragraph. Page 139, 129.
The instant case has been registered and proceeded against the OP illegally.
So the case is registered illegally. This is an allegation.
Allegation.
What allegation? Why will a witness say that the case has been illegally registered? Ask him to show cause.
OP.
So you're bringing a dispute to the tribunal that you are illegally registering case against me. How can it be? Abul Hussain, son of Koimuddin, of village Phul Katari, whose evidence is available at page 139, to show cause as to why in paragraph 2, he had stated in affidavit that a FT case number 284/F/2015 had been registered illegally.
My lord, this.
You have to control yourself, Mr. Counsel.
My lord.
You just can't say anything in evidence, whatever you feel like.
My
Next
lord,
item.
Paragraph.
File affidavit. Otherwise, you are drawing contempt against him. You are bringing the judicial institutes to a disrepute. You are lowering down the institutions. Next item. And be careful in your wording in your affidavit. You just write whatever you feel like. Don't do it.
My lord, this paragraph 3 and 4 part, my lord.
Whatever. We have read it. Para 3 is quoted as indicated. We are quoting it.
No,
also.
no illegal. Para 3, no illegal, my lord. My lord, sorry, my lord.
The next item.
My lord, sorry, my lord. Para 3 is-
File the affidavit. Otherwise, we are drawing contempt against this man. We may allow the writ petition, but there will be contempt against this man. You can't.
That
Do
is,
what?
my lord, that is the, sorry, my lord.
That is not the sorry. That is the. These people are just doing whatever they feel like,
My-
and it should not be. Remain within the confines.
My-
If you are giving evidence, give evidence. And this evidence requires only one line. That whoever this person name is,
My-
so and so is my sister, she is the daughter of so and so. You don't need a single word more than that. Why will you criticize the tribunal saying that you are illegally registering case against?
That part, my learned, my lord, is, advocate.
My lord, may I please give apology, my lord.
Yes,
My lord, item 13, my lord, interim may be continue, my lord.
it's still today.
Yes, till then, my lord, already,
Early interim to continue until further notice.
My lord,
highly obliged, your lordship.
One matter is there, no?
yes, there is.
But suggesting, can we take up the matter now itself, because the only one item is there.
I have no difficulty, in fact, I will
Possibly
be.
Mr. Nafi is not there. So we'll take up it.
Decision lordship has passed at the month of March.
It's a hard code.
Yes.
Can I take a look?
WPC 3363 of 2000.
Ascend it, Borok. You have a copy of it?
Yes, yes, sir. 3363 of 2007. Order dated 23/3/23.
This is the case where that SDO had report that one, or this is a different one?
In SDO method, lordship has directed us to file an appeal.
That why that Dhemaji
About the-
transferring to Dibrugarh. Now, which is this one?
This is a case where in Jorhat police lockup, the boy has committed suicide.
But that room.
Yes.
Rooms. But we submitted that it is suicide. So since no element of homicide in the the petitioner has agreed that following this decision, if the compensation amount is paid, he is agreeable.
But are we not required to give a finding on suicide or homicide?
Lordship, that is given, Lordship will find out.
I-
But,
Or we straight away accept the, if the petitioner does not object, we can straight away accept the stand of the respondent, it is suicide. And then pass this same order. Because here is, I just gone through that order. We analyzed the medical report.
Yes.
Which indicated to be a kind of a natural death. And just because it happened in the police station, by following that Supreme Court, I think we have,
Yes, Lordship, 2017,
how we have,
10 SSC 658, Lordship.
we
Justice Madan Lukur's.
but there we relied on Nilavati Behera.
Yes, Lordship.
Instead of going to Nilavati Behera, I think Justice Lukur's judgment is
Yes, Lordship. That-
better position than this one.
Yes, and Lordship, this judgment also covers, yes, in
So we
17.
have to ensure that there is no infringement individual right, a precious gift. Great responsibility to ensure that the citizen is not deprived of his right to life. Here, but the Justice local judgment is better because without any liability, without going into that question, you pay some compensation.
Following that, only, that is because it is
অকমান
possible-
ডেভিয়েট কৰিব লাগিব এইটোৰ পৰা এক্সাক্টলি চেম ৰেপ্লিকা এটা আনি দিব নোৱাৰে।
Otherwise, Lordship,
In paragraph 16, Milo has observed.
But difficulty, Mr. Nath. If we take note of the circumstance of the death, manner in which death had occurred, we'll have to give some observation that it is a suicide. We have no material to give that conclusion, arrive at that conclusion. If we, it is not suicide, it has to be homicidal. Considering, because other one was a natural death, it was very easy. We concluded it's a natural death because some adverse medical condition. So it's no one's liability. But now, if it is not suicide, corollary will be it is homicide. Moment it is homicide, we cannot leave the question open. Homicide means who had done it.
Logic, then logic.
Then it will be matter gets complicated. We just can't adopt this one.
Correct. Logic in that case.
What to
logic-
do?
Logic will see who has committed investigation, liability will be fixed. So, everything has.
Then we have to arrive at least some conclusion that it is unsatisfactory, that the stand of suicide appears to be unsatisfactory.
Sure.
Moment we make one line observation, converse is it is homicide. And homicide is a serious issue.
It's a serious thing.
And homicide, no court of law can keep it open. That homicide had taken place, but we are closing our eyes to it. Then how do you want us to structure our judgment then?
My respectful submission was, if lordship goes by the inquest report, the postmortem report, then from the postmortem report, I will make.
Is there any medical opinion it is suicide?
Yes,
Where is it?
the postmortem report is.
Page
No,
20.
where is the medical opinion? It is suicide? শুনিব লাগিব এইটো কাৰণ এইটো cardiomyopathy, that is the one. That disease was understood.
SDGM report is. there. So, the finding is clear.
Where is the PM report?
Page 24, Lordship.
Yes. Yes. Mr. Nath, the hanging is by rope or some cloth?
It is
No, no, what's the, what does the report say? It's by rope or it's by cloth?
a synthetic type.
No, maybe material is synthetic. It's a rope or it's a piece of cloth.
It's from the piece of cloth. Ultimately, it can't be a some portion. of
Some
the cloth,
torn portion of a piece of cloth
torn portion,
or the piece of cloth itself.
torn portion of the
Torn portion of a piece of cloth.
which was actually used in the broomstick.
Okay, it's basically rope then. Rope only hobo pare. পকাইলে সৰু গান পকালে সি rope form ল'ব ডাঙৰ কাপোৰ গান পকালে সি rope form নল'ব rope হ'ব মানে much thicker rope and the material used to commit the heavy is always lesser in thickness than the ligation mark. Ligation mark cannot be bigger than the like it cannot be less than lesser than the itu pun pasal itu baru digital itu hanya number. And secondly, it took in the lockup. As if we keep here, Master by and suppose you did a Kunwayani. So little height to opener height noise. That report is not there. So the window there will be quite window height. Window height of a personal difference is very less. Suppose a rope is tied to the broomstick put across the window. The rope will take another 6 inches or something of it if it is hanging. So the person has to put his neck inside that 6%, 6 inches less or even more less. 6 is not busy or the more to a foot money like a price. She a foot of the tears of Manuti Ulumi Take, the Gori Matit like a take. Can I get suicide for you? Suicide could be body to robot level so it should be free to come down. So ensure body right over some further space for the body to come down. Number one. Number two, you have to do it Only when his two-wheeler chair is there, firstly climbing to the chair. আমার গ্যারোজ বিক্রি করে সব কিছু আছে মানুষ তো ছিল এটাকে হঠাৎ দেখে কবর করে ফ্লোর তো নোয়া করে ফ্লোর করে বসে দেয় So he goes in. Yeah, to bathroom, toilet, to floor বসে না যায় How do you hang? Not possible. নিজে করবো বেলিকে সহায় করে দিলে পাৰিব Really for it. This is the question going on. Over forehead, left shoulder, confusion in the left forehead, abrasion. So these injuries shows that this person was subjected to something by the police, subjected to some kind of treatment by the police, resulting in these injuries. এটা হব পারে এই মার খাই পারে এই ভয়তে যে ফেলে মই সুইচাইড কৰাই ভাল নহয় এইটো মোৰ পিছত ভয় খেলে মই ক'ব পাৰে আৰু তাকে মই সুইচাইড কৰাই ভাল আৰু ফেচ কৰা আনটো হ'ব পাৰে এইটো কৰি একটি হেভি হয় না ইয়াৰ ফলত মানে আৰু এটা মজা দিয়ে তো সেটা জানি ফেলে কমিউনিকেশ্যন এইটো কবি নেনে কথা পাওঁ দুটো বেছি জোৰে লাগি মৰি থাকিম Mr. Nath, the biggest difficulty we are finding to accept will be suicide when a bamboo pole, which is a part of that broomstick, is put across two windows or across anything on a toilet of a police station or jail, police lockup. That pole will not be around the ceiling. Just,
The photographs I have seen. What is happened in the lockup room? Just behind the lockup room, some portion has been kept for using as toilet. That has been just a wall. Two walls have been raised, not.
not complete work.
Ceiling.
No. See, in a jail or in a police lockup, these toilet walls are never complete because somebody has to keep watch on that person so that he doesn't commit suicide. No, it's a part of the manual. You visit any jail, there also you'll find that the doors and the walls are always half.
Just.
So now what will be the height of this half wall?
As for the photograph I have seen, one can touch like this.
See, now let us visualize a situation that wall is slightly more than the normal height of a normal person. Okay. You put one bamboo stick. To the bamboo stick, you will tie one rope. Rope has to be at least 8 to 10 inches below the bamboo stick in order to put your head inside. Fine. So the height of that place is reduced further. The remaining height, it's likely to be the height of a normal person or even little less than that. If a person cannot stand straight, he cannot hang himself because unless it is your case that the person put the rope in his neck, then he bent his knees and put up his knees so that the ankle touches his thighs or that buttock portion, so that the height of the person is reduced and he gets hanged. This is medically impossible because when the pressure of the hanging comes, no one can have such a mental determination that he'll keep the legs bent. Immediately he'll make it straight because that's the first reaction of every living being. Have you noticed when a chicken is cut in a shop, when the head is severed, what does it do? Firstly, it grasps for all kind of airs it can take. It doesn't realize that the head is already gone. Still it tries. Similarly, this man will also try to get air. When he gets a little strangulated by the hanging, he'll try for some air. Immediately, involuntary reaction is his legs will become straight. He will again stand there. It is not possible to hang in that manner. Howsoever the nature of the injuries, the modis may show similarity with the injuries. Because that's an involuntarily human, number one. Number two, for hanging, the only way out is, have you seen a gallows? They put the rope, there is a false floor, and the man is standing there. All of a sudden, the floor is removed. One spring kind of a thing is there, floor goes away. So the man gets hanged by the weight of his body. So hanging is always by the weight of the body. So either you stand in a stool or a chair, put your head inside the rope, manage to remove the chair or the stool, you get hanged. Here, in this case, there is firstly space constraint, and secondly, there is no stool or a chair. So it's not possible to get hanged. This is why we are having difficulty in accepting the presentation that it is suicide. Because moment we accept it, we'll have to give a legal reason why we are holding it to be a suicide. Now, if it is not a suicide, nor it is a natural death, it's an unnatural death. Reports are there. Third option is an inquiry for homicide. Moment it is inquiry for homicide, we just cannot casually give a compensation by following that Sahira Banu or that passage of the Supreme Court judgment. Because homicide parallelly invokes another offense being committed. This is the difficulty. Otherwise, we are ready to accept. But Sahira Banu, one good thing was there. Materials showed that it can be concluded it was a natural death. Natural death means maximum will come is whether more treatment could have been given, could not have been given, all those aspects.
Here, before Lordship goes to the third option, that is homicide and the inquiry.
No, we are not going to a third option. We cannot accept the first option because of the reasons I have told you. Unless you overcome that aspect.
Lordship, kindly allow us to place the medical reports, opinion of the expert doctor.
No, medical report and experts are only indicative. But the court also has to logically and reasonably accept it. And also arrived at a conclusion that it is possible for the event to have taken place in that manner. But when otherwise, it's an apparent impossibility, then no amount of medical evidence can convert that impossibility to a possibility.
In that case, allow us to make our submission.
No, on this question we have raised. Not submission in general will hear you definitely, but specifically on this.
There are cases where allow us to play, but there are cases where by sitting also hanging can be done. Somebody may hang by sitting.
Yes.
There are instances. I'll place.
I understand. What is the mechanism? Please explain us. Hanging by sitting. Modi says only one line. It is possible. So again, sitting means existence of a chair.
Sitting on something else here.
Which else? What is the item that was available to sit?
No, but the thing is that.
Let us see. At least have some idea of the photograph. There was only a.
And the photograph of this particular instance.
No, just show it from there. We don't want to. No, just show it from there. In what manner the person was sitting. chair.
Even by sleeping, my lord. Even there.
Even by sleeping also.
Sleeping.
Sleeping where?
In the floor and caught himself hang in the post of the bed. As per his photographs.
These are rare cases.
Other one is in
No,
the
these
sofa.
are very difficult, you see. Ultimately, see, death by hanging is using the gravitational force and the weight of the body.
Exactly.
These are the two things. In whichever position you can use the gravitational force and the weight of your body, you can do it. Sitting, sleeping doesn't matter.
Time factor. He doesn't get, well, it's in a fraction of second, he doesn't
No.
get time to
In
react.
these kind of things, it may take a longer time.
No,
Yes.
No. Well,
The sitting, how did they do it? Not going to show the photo.
He is sitting,
No, you don't just show the photo. How he did it? The rope is tied to the
his neck.
neck.
The tighten is somewhere in the upper portion, in the roof or ceiling or side there. And there was
Okay,
somewhere-
when then
and-
after that, what he did?
And he is sitting in the bed.
Then how the
So,
gravitational
that this photograph says, but how that is not
No,
explained.
explanation.
and then how is it explained? Please tell us. Please read that.
In some cases,
It is recorded as
Yeah,
term is
area
medical
for
term.
answer, body on the display, medical.
Medical term is it is partial hanging.
Terms are there. I want to ask you how it happens. And then examine whether in this case it could have happened.
Okay, finally, what I have seen, I'll conclude, finally, what the differences between hanging and strangulation, ultimately, those are the factors to
No,
see
we'll go to
whether
technically,
it is strangulation or not.
we'll go to technically later on. First, find out the possibility.
Yes.
Yes, please read. What explanation is given?
Explanation.
And what is the photograph of the first visual of this deceased person?
Okay.
In what position he was there? Okay. Suppose theoretically possible when sleeping and sitting. This person, the first visual, is it sleeping or sitting or standing?
Standing.
So if it now, so we rule out the other two.
No.
So after committing suicide by sleeping or sitting, the man cannot be expected to get up and then keep standing for the photograph to be taken. No. Mr. Nath, theoretically possibility because it is written in one book and one picture is shown. And the possibility of that happening in the instant case, both has to be established. Your picture and the book shows it is possible. As it is possible, in this case also, it may have been like that, cannot be the answer. Then we'll also have to show that in this case, it also happened like that. So answer will be given by the first photograph as it was found. Before the body was moved, the photograph that is
Yes. Well, in fact, before moving the body, it was photographs were taken, videograph was also taken. Because these photographs are just
it's too depressing. I don't want to see photo. I want a description from you how it is. You see the photo yourself. You only tell us. I go by your word. Was it in any kind of a sitting or a sleeping position?
No, it is in the report also, standing. It is-
Standing, I understand. So now, how do you explain? See, Mr. Nath, your responsibility is to make submission. Our responsibility is to convert it to a judgment. And that has to be based with legal reasoning. So till we are convinced that we can give a legal reasoning to accept that, we are bound to ask you.
In that case, look, consider the possibility and the conditions, the entire thing. Don't you? Since this is. I have- I have- I'll make my submission. Otherwise, I'm ready to do medical reports and other things.
Opinion regarding cause. The postmortem says opinion regarding cause is kept pending till the receipt of the report of chemical. What is the opinion ultimately? No opinion, what is the medical opinion?
Opinion says-
Because here it could be. Because page 28 says opinion regarding cause of death is kept pending.
Because of FFL.
Understand? Now what is the opinion?
Especially resulting from having any which was antemortem and suicidal events.
That's what asphyxia.
As by the injury.
So main cause is asphyxia. Asphyxia means because of the pressing of the trachea portion, the person is unable to breathe. Because of that, the oxygen doesn't flow to the brain.
And apart from that, during the inquiry, the doctors were examined and the report has been collected from them. They are released. I have some injury marks were there in the body, but they said that the injury.
Okay, let us do one thing.
Injuries are not.
Who is the medical authority here given this opinion? Ask that person to remain present in the court. We'll ask him.
No, all of them. This is assistant associate professor, Department of Forensic, Rohan Medical College.
Ask the respected doctors to remain present. How they can explain it?
Yes.
If they can explain it, we'll accept their explanation.
A. The report, their report.
Let Dr. Kakoti, Dr. Soros Phukan, and Dr. Remain personally present before the court to explain why they have expressed a medical opinion that in this circumstance, there is a possibility that it is suicidal. Let them explain. They'll be in a better, they are technically more experts than us. They'll be in a better position to explain. If they can give a satisfactory explanation, we'll accept it.
The previous case is the queries made by the officer during the course of inquiry, and these are their. Can you see the previous case? And the entire.
No, let us go to the core aspect.
These are the answers of the query.
These are the answers of the officers, the doctors, and the.
So,
Can you see the previous case?
So let us also ask them some questions.
The previous case.
Inquiry man asked question, got the answer, got satisfied. We are not bound by the satisfaction of the inquiry man. We'll arrive at our own satisfaction. Let us, we'll also put some questions.
Because the videographs and all these things were placed, the photographs, the reports were placed. Ultimately, this conclusion has come.
No.
At page 190.
Mr. Nath, that is precisely we want to ask these doctors that see these photographs, see these circumstances. Please medically explain us how it had happened. If the doctors give a good explanation, we'll take note of it or ask them to put in an affidavit on that purpose. We'll accept it. But otherwise, if you apply a logical mind, have you noticed the complexity?
No, I'll make my submission that this thing.
What submission you'll make? You are repeatedly saying, I'll make my submission. Please, what are your submissions?
No, as regards the situation under that situation, whether a person can hang on explaining the photographs and the position of the place. Well, I am not ready today because on last occasion, he said that 5 lakhs rupees case.
Okay, so that way you didn't prepare.
Yes. Otherwise.
In fact, Mr. Nath, even we were agreeing or passing the same order. But after reading the earlier order, we have noticed that that was a totally different circumstance. Here, to pass a similar order, we'll also have to arrive at one particular conclusion. We are deliberating how to arrive at that conclusion.
Ultimately,
No, কেনেকে মই বুজি পোৱা নাই। আৰু যদি মোদীয়ে কয় that those two positions also it is possible, we accept it. But here is a case, it is not done in that manner. To accept Modi that it is possible, the corresponding photographs also ought to have been of the same position, that it was done in that manner, so it is possible medically, so it happened. But the corresponding photographs are at a variance. Standing photos, you were yourself saying, Mr. Nath.
So in the enquiry report, we have annexed. In the enquiry report.
Mr. Nath, who is saying you have not annexed?
Sorry.
We are deliberating on a particular question, whether it is medically possible for that event to have taken place in the manner projected. And we are bound to examine it, and we will examine, in fact.
Malad, the report, I am Malad indicating that his feet was touching the floor after hanging. This is in the report, and photographs and all these things are, videographs, all are. available.
So what is the inquiry report regarding the height of the bamboo pole, horizontal bamboo pole from the floor? Had anybody recorded it?
Height of the one.
No, height at which the horizontal bamboo pole was kept, had anybody recorded it?
Exactly, it is not.
It ought to have been recorded to justify what you were trying to say.
But photographs.
See,
Photographs.
Mr. Nath, your line of argument is you are basically hovering on different possibilities. You are producing Modi, you are saying all different kind of presentations. See, mere possibility is not sufficient to arrive at a conclusion that it happened that way. The other impossibility also has to be ruled out. This is why we are asking you. Your line is by producing stray materials here and there, this is also possible.
My submission is relying on the medical reports.
Otherwise, we are ordering a inquiry by the CID or somebody somewhere. Or there's no other way out.
Considering the evidence is sides to the even inquiry. I'm pressing.
I understand. So therefore, we are repeatedly asking you one question. We have already spent 45 minutes on this till now. We are not progressing anywhere. You are just going in concentric circles. Go from one point, take a round, again come back to the same one. And we again start with the same thing, again take one round and come back to the same one. Let us progress further. So that we can also arrive at a judicially acceptable conclusion. And we are repeatedly expressing we are unable to get on material of that nature from where we can judicially conclude this. Aspect. No. Hanging is there, no difficulty.
It is homicidal or
Whether it is homicidal or not. To be suicidal, some circumstances has also to be established that beyond a particular moment of time, the person who had hanged had no control over the event. If that circumstance of not having control over the event anymore is not established, it cannot be concluded that it is suicide. Because the moment he has control over it, the involuntary reaction will be to avoid it in the last moment. That's a involuntary reaction of every animal, not just human beings. When the death is just about to happen, the involuntary reaction is to escape from the death. Before that, howsoever planning you may have made to die. So circumstances must be such that beyond a particular time, the person who intends to die has no control over and it is bound to happen there. This is where we are not getting material.
But from page.
Are we clear in what we want?
Yes, yes. So from page 24, my submission is that it is the hanging is suicidal.
So your submission, we have heard you, not just once. We have been hearing you for a long time now.
Referring to the.
But please justify. Okay, we are framing the question. That suicide must also correspondingly have a circumstance which will exist after a particular point of time where the person will have no control over that circumstance. This is the basic requirement of a suicide, because suppose you are committing suicide by touching a live electric wire. Once you touch it, no escape for you. But if there is a circumstance for you to escape from it, moment you touch the live wire, the involuntary reaction of the body is to take it out. But electricity current is such a high energy, it attracts your hand or whatever you hold, it doesn't allow you to take it. So that is the circumstance which is beyond the control of the person.
But that circumstances relating, I'm not in a position to.
You have to submit. You
today.
take the help of your experts.
No, I'm not in a position today.
So I understand. So we want to have interaction with the doctor also. Why they felt it like that?
No,
So doctors may have their own reason. Let us have their reason.
Yes, yes.
Right.
Yes, yes. And otherwise, the surrounding circumstances or that particular place, I'm not ready. If that is to be explained, I'm not ready today.
We already told you. Your responsibility is to make your submission. Our responsibility is bigger. We have to give a reasoned order.
No, for that, I'm praying for some time so that I can frame my submission on the surrounding circumstances.
It is notice that the medical evidence as well as other evidences as well as the inquiry report are being relied upon by the respondents to raise the submission that the death of the deceased was because of suicide. The circumstances is that a horizontal bamboo pole was put across the half walls in the toilet of the police station lockup, to which a piece of cloth was attached by making it the material to enable the deceased to hang himself to death. Although the materials available on record do not indicate the height at which the horizontal bamboo pole was put, measuring it from the floor of the premises, but it is stated that it was possibly of a height of an average man. Average man. Or you can ask the police to measure that lockup is still existing.
Still exists.
He can put a
Yes.
measuring tape and measure it also. That will be no difficulty. It is also stated that the hanging took place No, it is also that the photographs taken immediately after the alleged hanging shows that the deceased was in a standing position. It is argued by placing certain photographs and materials available in the Modi's medical jurisprudence that hanging can also take place in a sitting position or even in a sleeping position. But such materials may not be of help, as because in the instant case, it is admittedly the deceased was in a standing position and his feet were touching the floor. An understanding of the concept of suicide is that the person who intends to commit suicide, having set in motion the events which would lead to suicide, would further not be in control of the circumstances and the process would be irreversible. Particularly taking note that it is an involuntary act of any being who is about to die to take an evasive measure, whatever possible, if the circumstances allow, to avoid the death. The respondents may explain that if the death had occurred in the manner as indicated in the photographs, that is, a rope is being tied to the horizontal bamboo pole, a rope stroke cloth, and the hanging had taken place and the feet of the deceased were touching the floor. What prevented the deceased to resort to the involuntary instinct just before the death to avoid the death, so as to arrive at a conclusion that the circumstances indicated that it was in fact a suicide? The respondents may respond to the said aspect on the next returnable date. We have taken note of the opinion rendered by the authorities in the Jorhat Medical College and Hospital, comprising of 3 doctors, namely, give the names of the doctors, Mr. Nath, give the names of the doctors.
Yes.
Comprising of 3 doctors, namely, Dr. Swaraj Phokon. One is Dr. Nandini Pegu, Swaraj Phokon demonstrator, Nandini Pegu assistant professor. Other one is N.M. Kakoti, associate professor. Suicide report, this is wherein, in response to a query by the inquiring authority against question number 5, they have given the medical opinion that the ligature mark suggests a suicide. If it is the opinion of the medical authorities that the ligature mark suggests a suicide, the medical authorities may remain present before the court to explain under what circumstances as indicated above, a suicide could have taken place. And the position in which the alleged suicide had taken place, why the deceased did not involuntarily react at the last moment to avoid the death. Or was he drugged or something? That his all senses were lost and he didn't even realize. No, nothing like
The
that.
report doesn't suggest. From report, I have not seen.
Otherwise, see everything. Try to kill a cockroach. Even if you hit it a little, first attempt is to how to run away.
Mhm.
You have you noticed one thing? Those mosquito sweaters you have noticed nowadays, the electric one, badminton racket kind. You will see mosquitoes all around, but when you go with that racket in your hand, you'll find all the mosquitoes have gone away from you.
Yes.
This is a natural reaction of every being, including a mosquito, to escape death.
Correct.
No one, the suicide happens because of an adverse mental state just prior to the happening. But when the happening takes place, the motion is set on. Once it happens, the involuntary reaction is to avoid it. Even your mental state overtakes that. But here is a case, I don't know, I can't conceive of a situation why, how it could have happened. If necessary, you can bring in theory books on suicide,
Let them.
any material, you also look around.
Lots of questions.
Lordship, otherwise, the Moody's book, the standing, the suicidal photographs which are standing, all in most of the photos, there are some tool or table. or-
Something has to be
Yes,
there,
something
because as
is
I told
used.
you,
Yes, Lordship.
suicide, two things are used. One's the gravitational force and the other is the weight of the body.
Yeah, in
For that, there has to be a gap between the floor and the
the
Factor is the body's weight. Body, without body's weight, no,
body weight.
Cannot-
Gravitational
cannot-
pull is bringing it
Yes.
down with a
It has-
force.
has to be there.
standing photos also some tool or table or bed. Something is used in the standing photos.
So the other one, we can rule out the sitting and standing because the photograph doesn't indicate.
Only on possibility or impossibility, I just indicated.
Just look into it.
I'll take up on that.
How we can conclude what it is.
It,
Not the indications. How we can conclude.
Good.
What you have referred till now are all indicating materials. That it is also, it may have happened. Or all the three doctors did not remain present, one of them can come. One of them can come conferring with the other three. We have already said the question. And explain it to the court that this is what we are medically, we have understood about the problem.
the, I don't know where are they? Any one of
There
them.
must be in one of the medical, maybe
Yes.
in Guwahati also. If one of them is Guwahati, it will be easier for him to come.
Any one of them.
Any one of them.
Lots of questions.
And any one of them before coming, that one person will confer with the other two. So that a collective view is presented before the court.
Lots of questions.
You must be called somewhere else. Heard in part, list on further hearing.
Mal.
When you ask?
Well, the officer has to come. Kindly give us 1 week, at least 1 week time.
Fixed date at the next Thursday.
Next Thursday. Let it be on first, Malad. First.
Not on first. Either one day before or 5 days later.
What? I'll try.
Make it day before. If difficulty will accommodate you.
I'll try.
Make it next Thursday. It's 1 week.
I'll try.
If anybody, all the three has a personal difficulty, we'll accommodate you.
I'll try.
But ask them, come ready with the medical information about how and how it could have happened. We just want their expert view, not on something else. Not for any reprimand or this or asking why you did this, why you did that.
No.
We want their medical view.
Gotcha. Gotcha.
Their expertise in this
Yes.
subject.
Gotcha. Gotcha. I'll convey. On 31st. Next, I'll try.
Interest. Otherwise, they're thinking of writing the same judgment, but this respect will remain.
I'll also see the videograph and photographs, everything, what is there.
You want to see?
Yes, I'll see.
Okay.
On the other day, Lordship, in a case of Borpeta, Lordship has directed to take us the videograph of the postmortem report. The videograph has come. In inquest and postmortem report.
What was the matter?
It is again a suicide.
Which was one was that?
That was Borpeta jail.
That Gamusa.
Gamusa.
Gamusa and ligature mark of 2
Ligature mark of
centimeters.
2 centimeters. That videograph has come out. I have seen.
What does it show? That it suicide only?
If we go by the report, it suggests it is suicide.
Anybody having expert knowledge on suicide, any authority?
Till now, some decisions are there. Supreme
No
Court decisions are,
decision.
and the
Supreme Court
Modi-
decision is always on facts. Expert authority on suicide.
Modi's
Because some are there. Earlier, Mr. Nila Dutta was there. We'd have taken his help. Because one day he gave a very good presentation, detailed presentation in one of those criminalities. Where it is possible, where it is not possible, and why, and everything.
Now, some Supreme Court decisions are there. Discussions are there in those cases.
Find out where it is.
Such a question. Some of them I have seen. I'll try.
Or anybody around who is an expert,
Some doctor has to be, ultimately, I have to consult some doctor.
some forensic doctor. If not these 3 doctors, anybody else can also come forward. But they have examined it, that's why.
They
Or along with them, another expert can also come. He can
No.
put his views.
Now, it is difficult for us to bring a doctor before your Lordship, because ultimately, without the honorable court order,
No, we can pass an order. If
They-
you
they
if you say so,
no,
that so and so is an expert, his views will be of help, we can pass it order.
Lordship, let us try with these 3. We'll see. In fact, I have to also examine who can be better.
These are most difficult situations
Correct.
where it may be yes and maybe no also.
Now,
When both are equally there, maybe yes, maybe no, then it is difficult to accept the yes. Questions will come, why didn't you accept the no then?
we are
So we have to look for maximum material which will allow us to rule out one of the 2.
one of the 2. That is what we are doing. That is what we are.
And we are trying for that.
In fact, because of Lordship's query, we have seen the photographs, we have seen the videograph, we have seen it is because of Lordship's query ultimately. Otherwise, we were concentrating only on the postmortem report and the inquest report.
Reports are just view expressed by one person from there. And that view will be accepted when it is backed by reason. You can go if you are in a hurry. If that view is backed by reason, it is very good. We can always examine the reason and accept it. Yeah, this is the right view. And whatever order we pass, we are bound to arrive at a conclusion.
Correct.
If we blindly follow all this, we will also put ourselves in the same level that these authorities who may have given an opinion without analyzing it. So what will happen when a fact may not have existed? The existence of it will be accepted by court. Why? One person said this, one person said that. Yes, it is said. We also accept it. We also say. No one knows why we are saying. Hmm. And tomorrow, suppose he goes and test our order in the Supreme Court. Again, it will come back. The High Court to give some more reasons why it said yes, so.
Proxima, to the extent possible, we'll try and to find out what can be done.
Mr. Nath,
No.
have you examined the knot?
Yes.
How was the knot?
In the postmortem,
No. How, in what kind of a knot was given?
so that position of not I have seen.
Not position, kind of knot. There are various kinds of knots. Those mountaineering people will be able to give you a better idea. There are different kinds of knots in a rope.
Good.
And some knots are such that once it slips into a particular position, it is not reversible. So once this man managed to get the knot to that position, even if his feet is touching the floor, he is knowing it.
Slightly.
No, he won't be able to reverse the situation. So ultimately he'll die of asphyxia. But most of the knots are slippery knots. Slippery knot is it will go in both direction. Just listen, have some patience. Slippery knot is a knot when a force is in one direction, the knot will go up and it will strangulate you. Moment the force is in the other direction, it will again slip out and come back to the original position. This is one kind of a knot. Another kind of a knot is once it goes and reaches a particular position, it's not going to reverse back. Mainly those mountaineering people, they use it. There's a particular knot is there. So that when they climb up with a rope on a stiff cliff or something, so that the knot doesn't come back again. Check up if any information. That is one only possibility.
Not I have not. I'll
Possibly that's the only possibility where this could have been a suicide. No other way out.
I'll check.
You also come prepared.
I'll try. In this case, I am learning a lot of things, Lordship. I
Learn some more and help
Yes,
us.
I'll try.
And help us also to learn a bit more.
Definitely, I'll try my best. In this case also, otherwise the rope and the boomstick has not been examined as per my
Not been examined. Not been seized also.
It's been seized, but it was not for forensic examination has not been done. But as per the Moody's book and as per
It should be done.
it should be done. It ought to have been done. Age determination is.
But then we'll have to send it back then for doing it. Not doing will not lead us to any conclusion either this way or that way.
After the body is in a hanging position, the bamboo stick is still there. It has not. The examination will be done when the possibility that that particular bamboo stick is not in a position to take the weight of the body. 50 kg it cannot take. Then examination of the question.
Bamboo stick is strong enough to take the weight of a body.
50 kg.
Mhm. Especially those used in the in the broomsticks, they're strong enough.
The picture shows that the body is in a hanging position, the broomstick is there.
It is a branch of tree.
Let's go back. Read some more. Read more on the
Yes,
this mechanics of that's all.
Not traditional, not and all those things.
Not these that whether it arrived at a circumstance from where even the involuntary reaction of the dying person to escape death could not have prevented him from reversing the situation. This is what we want to know. Once you establish this, we